This is Foundations of Property Law. We're into week 11 of term 1, 2020, and this is our second last week. So next week we'll do a revision. We have a lot to cover tonight. Now, the topic specifically that was allocated for me to discuss is equitable property and equitable doctrines. I have recorded, or I've uploaded a Zoom session that I recorded some years ago, a couple of years ago, on resulting trusts and constructive trusts. You may have seen that. That's when I was teaching, I think, trusts, and there's been about 7,000 or 8,000 views on that. So some people might be finding it useful. So please keep that in mind. Much more depth to what we're dealing with tonight. Generally speaking, in the context of property law, that which is legal represents that which is registered. And the equitable remedies or equitable rights relate to interests which are not registered, as in with the registrar of titles. If you hang with me until the end of tonight, I'll give you some information that will really help you in terms of the practical application of property law. So that's a little teaser for the end of this session. So tonight I want to start by discussing trusts in an overview. Now we have a whole unit for this, so I'll do my best to condense it. Essentially, when it comes to trusts, there are really two types. There are those that are express and those that are not. And some examples of express trusts are fixed trusts, discretionary trusts, charitable trusts, testamentary trusts, and unit trusts. So they're all fixed trusts. They're all express trusts. So what's an express trust? It's essentially one where we have an intention to create this express trust. It's not something that's imposed as a result of a court action. It's an express desire to create a trust and hence an express trust. There are three parties typically involved in an express trust. Number one, the settlor, the person, for want of a better term, who creates the trust. Grandma says, I want this $10 to be used to open a bank account for my grandchild. Grandma's the settlor. Second party in an express trust is the trustee. Here, I'll give it to you so you can open the bank account for your daughter. Mum is then the trustee, the one who receives the settlement sum from grandma, the settlor, and banks the money, not for her own benefit, but for the benefit of party number 3, the granddaughter, who is the beneficiary. So 3 parties in an express trust. We also need 3 certainties. There needs to be a certainty of intention, there needs to be a certainty of subject, and there needs to be a certainty of object. Grandma's intention is quite clear, it's quite certain. This is to benefit my granddaughter. There's a certainty of subject. Here's the $10 note, I'm handing it to you. That's the subject. And the certainty of object. Who is the object? Who is the beneficiary? It's the granddaughter. So in order to have an express trust, we need essentially the 3 parties and we need the 3 certainties. I mentioned there are a few types of express trusts. A fixed trust is the most basic. The example I've given you is a fixed trust. Let's vary that a little. Grandma says, here's $10, please bank it and use it for the benefit of your children as you see fit. In that situation, we still have grandma as the settlor, we still have mum as the trustee, and we still have the objects, the beneficiaries, are mum's children, in other words, the grandchildren. But it's discretionary in that mum can decide where the money goes year by year on the interest in that trust, or ultimately when there is capital to be distributed. And of course, an idea of a trust is that it can be supplemented. You know, the $10 kicks it off, but then from other sources, that corpus can grow. So a discretionary trust means the trustee has a discretion to allocate the income and the capital as that person sees fit. Charitable speaks for itself. Testamentary means a trust created in a will, hence testamentary. And a unit trust is where the proportions are fixed between a number of beneficiaries. An example of a unit trust, which is still an express trust, might be where we have two people wanting to go into business together, wanting to keep their shares separate. They buy a company off the shelf. That company becomes trustee of a unit trust, and 6 units are allocated to A's side and 6 units are allocated to B's side. So as money is generated through the trust, the money is distributed to the unit holders in accordance with the terms of the unit trust. Are you with me so far? I hope so, because we've got a lot to cover. If you have any questions, please let me know. Express trusts were created by a declaration. Grandma says, here is the $10. I declare that is for the benefit of, by a transfer. The money goes from grandma's account to the daughter's account, or by direction. Whatever it is, you still need the 3 certainties. All good? Contrast express trusts to resulting trusts and constructive trusts. Resulting trusts relate to the presumption of something being provided, but in someone else's name, but still yours. And a constructive trust is something that is imposed by a court, whether you like it or not, in circumstances where it would be unfair or inequitable for the legal owner to prevail in being able to assert legal title. Now, you all know about adverse possession because that was the second assessment. So you know that there are circumstances where the legal title, the person who is registered as the owner, can be subject to an attack. In that instance, adverse possession. But a constructive trust is another example of where your legal title might be attacked. And last week we talked about Section 185 of the Land Title Act and the exceptions to the concept of indefeasibility. When we talk about constructive trusts, we're really talking about another exception of sorts. So when we talk about express trusts and resulting trusts, we're talking about something that was created in a consensual manner. It was deliberately created, as opposed to a constructive trust, which is imposed upon you as a result of a court action. But there are other differences. So when we talk about resulting trusts, there are different types. They can be automatic or they can be presumed. And now we're getting into the technical side of things. So the best way to explain resulting trusts is provide you some examples. Number 1, presumed resulting trusts. If you provide the money for something and it's registered in someone else's name, the law presumes you intended the registered owner of the property to hold that item on trust for you, even though the word trust may not ever have been used or documented. You pay the money. The law says you should have the beneficial interest, the equitable interest, through a resulting trust in that property, even though it's in somebody else's name. So there are two ways that we can have the presumed resulting trust come into existence. Number one, the first example, through the advancement of purchase money. And the second is by the voluntary transfer of property from A to B, where there's no consideration, no payment. In the first instance, the resulting trust is presumed because of the advancement of the money. If A purchased property in the name of B, equity presumes that B holds the property on resulting trust for A. And a resulting trust is presumed because of a voluntary transfer, because if A transfers property to B, equity presumes that B holds the property on a resulting trust for A. Are you still with me? All good? All right. But remember, what I'm talking about are presumptions only. They're not absolute laws. So they're presumptions, which means that they can be rebutted. And how are they rebutted? By operation of law in certain circumstances, or by the evidence, or a combination of both. So in a presumed resulting trust, a court gives effect to the trustee's presumed intention. A good case on resulting trusts to keep up your sleeve, put in your toolkit, and quote if you want an authority is High Court decision of Calverley and Green, Calverley against Green, 1984, 155 CLR 242. So how do we displace this presumption? Bearing in mind the presumption is just a starting point. It's not absolute. It means that essentially, if you want to rebut a presumption, the burden of proving that shifts to you. Even though you may not be the plaintiff, the burden may shift to you. And so what can you do? You lead evidence. And you might lead evidence, this is the most common one, that the property was transferred to me, yes, I didn't pay for it, yes, but it was a gift. And if you can prove that it was a gift, you can establish then that the presumption of the resulting trust is rebutted in that circumstance. Another key case, keep this one in mind, it's very important, Muschinsky and Dodds. That's Muschinsky against Dodds, 1985, 160, CLR 583. So there's another legal presumption relevant to this area, possibly even more powerful than the presumption of the resulting trust, and it's the counter-presumption of advancement. And it works like this. Where the parties are in a certain relationship, and one might be seen as having an obligation to care for the other, the court will presume that any property that was transferred in those circumstances will be a gift for their welfare. The case that relates to that, Nelson against Nelson. So I've talked about the presumption of the resulting trust And now I'm talking about the more powerful counter presumption of advancement in certain circumstances. So in those circumstances, equity will presume that the property was indeed transferred as a gift or an advancement, is the term we use, to the recipient. Now it's a little old-fashioned, but when a husband buys property in the name of a wife, or there's a presumption of a gift. Parent buys property in the name of a child, there's a presumption of a gift. There's the presumption of advancement. And the presumption applies to voluntary transfers. However, it's still only a presumption. So what I've been talking about so far in this little segment is presumed resulting trusts. I mentioned there are two types of resulting trusts. The other is automatic. What's an automatic resulting trust? Well, this is different because it arises in a totally different way, and it arises as a result of the failure to create an express trust. I mentioned before there are 5 or 6 different types of express trusts. Now, you might get it right in creating that, but what if you unsuccessfully attempt to create a discretionary trust? You might be left with a resulting trust that is called an automatic resulting trust. I mean, a whole lot of reasons why an express trust might fail. Bear in mind, to create an express trust, we need the 3 certainties, don't we? Maybe you haven't got one. Maybe there's a breach against the rule of perpetuities. Maybe the reason for creating the express trust no longer exists. So, but the point is that if you have an express trust and it fails, equity may still impose a resulting trust by presuming an intention on behalf of the creator for the trust property to revert back to the creator, for example. So grandma gives the $10 and there's something goes wrong. What do we do with that $10? If we look at the fact that the express trust has failed and we consider automatic resulting trusts, the law says, equity says, the presumption is that it goes back from where it started. So the legal principle then is to invoke or to argue for the existence of a resulting trust which is automatic and it's equitable. So what other express trust failures might there be? The trust might be void because it might be uncertain, might breach the rule of perpetuities. It might be illegal. The trust might be unenforceable. It didn't fulfill statutory requirements to be in writing or whatever it might be. It might be that the intended beneficiary predeceases the testator, or it might be that the intended beneficiary says, I don't want it. I'm not taking grandma's money, says the grandchild. So there's some of the reasons why the express trust might fail. Express trust fails, think automatic resulting trust. Now, all of this is subject to statutory intervention, because I'm really talking about equitable principles here. A key statute relevant to this area of law is the Family Law Act, 1975, Commonwealth. Consider section 79, to do with the alteration of property interests in the breakdown of a relationship. And essentially the court, by virtue of that section, can put to one side a lot of these equitable principles. So these rules that I'm talking about are always subject to contrary statutory provisions, and statutes will override the common law statutes will override equitable principles. Section 79, Family Law Act, is an example of that. And bear in mind that since 2009, parties to an eligible de facto relationship that is broken down have the same recourse to family law proceedings as was the case with married couples up until that time. So far, I've been talking about express trusts, and I've contrasted express trusts to resulting trusts and constructive trusts. Let's move on now to constructive trusts. Before I do, let me see if I can see any glazed eyes, hair pulling, general discontent. No, we're okay. You with me? This is fleshed out in a lot more detail in the other video that I referred you to. Constructive trusts. This is where equity really bears its teeth, so to speak, because when it would be inequitable, when it would be unfair for denial of the obligations of a trusteeship, then by operation of law, the law creates a constructive trust. And when we talk about anything in law that is constructive, and we talked about this a few weeks ago, when we talk about something that's constructive, what we really mean is as if it were expressed. Constructive means as if it were. What's a constructive dismissal? Well, I wasn't dismissed, but it's as good as being dismissed. Do you understand? That's what we mean by constructive. So constructive trusts come into operation by the effect of law, and specifically where it would be fraudulent or unconscionable to deny the existence of a trust. A court may find the existence of a constructive trust despite the intention of the parties. I won't go into any more detail on that specifically, but when you're looking to have the court impose an equitable remedy or to make findings of a constructive trust, for example, bear in mind that equitable remedies are flexible and they're also discretionary. And the appropriate remedy will depend on the circumstances and what the party wants. So it may be that parties seek an equitable remedy based on recovering contributions they made to a property, or it may be by reference to the increase in value of the property. So if you're arguing that you have an interest in property and you're relying upon equity to mount your claim, then you can frame your argument and the relief that you seek in different ways. I hope that makes sense. Because equity is flexible and equity is discretionary. All right, all good? Soon I'm going to move on to estoppel. And I know this is a flying visit through equity, but before I do, I mentioned earlier testamentary trusts. These are created under a will. Mutual wills are the special types of wills where the parties essentially enter into a contract not to change their wills. People can change their wills anytime they like, but if they did that where they were part of a mutual trust arrangement, then they'd be in breach of that contract. Anyway, I'll get off topic. I will just mention one other case for you to consider, and that is Baumgardner and Baumgardner. It is Baumgartner, 1987, 164 CLR, and it essentially follows on from the principles in Mishinsky and Dodds, essentially saying that equity will not permit the other party to assert or retain the benefit of property if it would be unconscionable for that person to do so. It's kind of a just general go-to case. If you're stuck for an argument Baumgardner's a good one to keep up your sleeve. Put that one in your toolkit. Just be ready to rely upon that argument where you believe that there is a degree of unconscionability and it's primarily based on constructive trusts. Let's move on to estoppel. There's a lot of equity in this for a property subject. But fortunately, I've lectured in equity and contract and now property. So it's kind of a good moulding of the three. Key cases to do with estoppel, High Trees House, but more importantly, Waltons against Marr. Okay, so where there's misrepresentation or where there's a mistake, there must be a contract. But sometimes, in the context of property law, there may be a transaction that's intended, but it never actually comes to fruition. But it might be that one of the parties misleads the other into thinking that there's no need for a contract, or there is a need for a contract, but it's coming. It's as good as done. It's on its way. The other party might rely upon that and act in a way that would make it unfair for the party that misled to go back on their word, even though technically there's no contract upon which to rely. So this is estoppel. This is the general category of circumstance where a person is prevented from relying upon what statements they had previously made. You're stopped from doing that, saying that, because of what you've already said. So estoppel means to stop or to hinder. And as much as possible, the law tries to be consistent in law and equity, in applying common law principles and equitable principles. So Walton Stores against Marr is a good case in that regard. There are different types of estoppel. I won't go into that too much now, but there's promissory estoppel, there's equitable estoppel. But generally speaking, for the purpose of what we're talking about tonight, it's really equitable estoppel, but you can almost think of them in a way interchangeably. You really do need, if you haven't come across, the full citation is Walton's Stores, in brackets, Interstate, close brackets, Limited, against Marr, M-A-H-E-R, 1988, 164 CLR 387. If you haven't come across that case, please keep it in mind because it will crop up time and again. And it is important in property law. I mean, you look at the facts of Waltons and Marr, and you can see that that is the case. What happened is this. Waltons was a department store, proposed to purchase land for its business. The seller agreed to knock down an existing building and build another one in its place to Walton's specifications. Walton said, we want this property, don't want the building, we want you to build another building, here's what we want. Now, timing was all important in this because for the seller to meet their obligations under the contract that was being proposed, they had to move quickly. Time ran short and they said, Waltons, we need your contract. Walton said, no, we haven't quite, we've got to do this and we've got to do that, but it will be forthcoming. We will get the approval to proceed. So the sellers knocked down the building, waiting for Waltons to commence, to sign the contract and complete. Waltons underwent a restructure and they then instructed their solicitors for a bit more time. A couple of months went past and the seller had spent a lot of money in demolishing and commencing rebuilding in accordance with what Waltons wanted. And then, of course, Walton said, no, we decided not to proceed. So the sellers went to the High Court eventually, and the High Court expanded and developed and incorporated this law of equitable estoppel into Australian law. So it's really important. Now, of course, under strict contract law in relation to real estate, there was no contract. So we had to create, the law had to create something to assist here. And it created this promissory estoppel in Walton's Stores and Marr. Now, there are 6 elements to it. Number 1, there has to be some sort of representation. Usually it's by words, but it doesn't have to be. Number 1, there's got to be a representation. Number 2, the person or party making the representation must induce the other to rely upon it. The person making the representation must induce the other one to rely upon it. Number 3, the party to whom the representation was made must actually rely upon it. So there must be actual reliance upon the inducement or the misrepresentation. Number 4, the party must know that the other party is relying upon it. So there must be knowledge of reliance. Number 5, the party that is relying upon it must then act to their detriment. Knocking down a building, for example. It's number 5. And number 6, the party that made the representation must have done something to fail to act to avoid the detriment. Walton stood back and just watched it happen. They didn't say, no, just hold on, there's a real chance this may not go ahead. So they're the 6 elements of equitable or promissory estoppel in accordance with Walton Stores against Mars. So it was a real development of the law in this area. And it's all to do really with unconscionability. And the effect is that promissory estoppel can occur in pre-contract negotiations. And it's a landmark case because in this instance, there was no consideration, even though it was in the context of a contract. But there has to be some sort of representation, as I mentioned. Silence is insufficient. And there must be the inducement, there must be the reliance, there must be the knowledge of the other parties relying, there must be detriment, and there must be this failure to act, those 6 elements. Oh, I know this is fast. All good? All right. So what can we say about estoppel? Well, it's not misrepresentation. It's not necessarily misleading or deceptive conduct. It's a little different to all of that. And it's more to do with inconsistent conduct. So it arises in circumstances where there was a clear assumption and there's a departure from that. And the law says, no, you can't depart from that assumption that was being made. Reliance was there, and therefore you're bound. You're stopped from denying that this is what you said and these are the ramifications. All good? Now that's all I propose to talk about on estoppel. Equitable doctrines means considering equitable remedies. If you've studied equity, you'd know some of the basic equitable principles. One of them is equity follows the law. Equitable remedies are available if a court is satisfied the common law remedy is inadequate or there's no satisfactory remedy in statute law, such as the Australian consumer law. Equitable remedies, we've already talked about this, are discretionary. Judges have a discretion to grant equitable remedies. Some examples: specific performance, forcing the other side to proceed, or an injunction, stopping the other party from doing something, or forcing the party to do something. They're both injunctions, prohibitory or mandatory. Another equitable principle, if you come to court, if you want to come into equity, then you must come with clean hands. Clean hands doctrine. It's to protect the integrity of the court. So the courts disapprove of illegal acts and they may deny relief for that, but also for bad conduct. So there are issues of public policy here. So bad conduct, for want of a better term, is generally discouraged. So if you find that you're under attack from the other side, ask, well, are they coming to court with clean hands? Are they really blameless in all this? Or are they doing something that should be discouraged and wrong? I know it's a completely different context, but if you're arguing against the legality of evidence that was taken at a scene, then you might ask whether there was a search warrant, and if there was a search warrant, was it executed properly and all procedures followed? It's kind of along those lines where you're saying, well, the other side really haven't done the right thing, and given that in this instance they're asking for an equitable remedy, and an equitable remedy is discretionary, Judge, do you really think that you should make that order? Given that we say, then they're not coming here with clean hands. All right, so that's it for equitable remedies. I mentioned earlier that whenever you're thinking about this area of practice, remember, of course, that statute law is fundamentally important, which is why I keep saying to you, go to the statutes first, because that's the most powerful of the sources of our law, the primary source of law. But really fundamental to this as well is contract law. Contract law in the context of property law is generally exhibited by, well, in Queensland, an REIQ contract, the Real Estate Institute of Queensland contract. Now, there are different types. There's for houses and land, for vacant land, for body corporates, for commercial property, for businesses. So within Queensland, there's a number of different standard contracts from the REIQ and other providers as well, and likewise interstate. So when you're thinking about the rights and remedies, please always consider what the parties have in their contract as probably the first place to look. And from there, you can then consider things like statutes. And when you read the contract, and if we have and I'm sure we have conveyances in our group, when you read the contract, you'll see there's a whole lot of information relevant to fundamental property law. And there's concepts. In the context of remedies, a buyer or a seller might affirm a contract, or they might terminate the contract. Affirm, saying, you're in breach, but we still want to go ahead. It's not quite specific performance, but it's a statement to say we are still bound by the contract, or it's a termination of the contract saying contract's at an end. So always consider what's in the contract. Also, in the context of statutes, remember generally the very powerful Australian consumer law, which is federal, but it's incorporated into each of the states, in Queensland through the Fair Trading Act. So when you're thinking about these remedies that are available, you've got this melding of common law and equitable, statutory, non-statutory, contractual and non-contractual. You've got to try and put it all together. Be very creative. And I mentioned specific performance earlier, meaning an application to a court or an order of the court, essentially forcing someone to proceed. And you can't ask, sometimes you've got to match the remedy with your action. So if, for example, you terminate a contract, then you really can't ask for specific performance, can you? You've got to affirm the contract and you to say, well, I'm keeping it on foot. So then when we get into the issue of termination, it comes into, we then have to think about things like termination versus rescission. If you've done contract law, you'll be aware of that distinction. So, and also the related topic of repudiation comes into it as well. It's a lot of terms. This is why I keep saying you need your toolkit where you can have ready access to this and understand how they fit together. So let's just talk about termination, rescission, and repudiation briefly. Rescission relates to things like misrepresentation or mistake. Termination is for basically breach matters, breach of an essential term, or a serious breach of an intermediate term, or repudiation by the other party of their obligations. Repudiation is where a party essentially renounces their liabilities under a contract, or they show a clear intention not to be bound. In those circumstances, that party is said to repudiate the contract. And if you're on the receiving end of this repudiation, what do you do about it? Well, you might be able to terminate, you might be able to argue rescission, you might affirm. But repudiation is saying, I'm not going ahead. Termination results in both parties being discharged from that time, but earlier rights and remedies remain. If you have rescission, it basically means that the contract, for example, is void ab initio, meaning from the beginning. If you've studied contract law, equity, trusts, this is going to be a lot easier than those who haven't studied those. I'm sorry. The other thing in the context of property law that I really need to remind everyone about is this. In equity, time is not of the essence. That's the general rule. But in contract law, in Queensland, in the standard contract, time is of the essence. It wasn't always the case. There have been so many editions of the contract, and at one stage it wasn't. And that was really weird. But almost always, for real estate transactions, time is of the essence. So what that means is that if settlement was to occur on the 1st of June 2020 and the buyer's not ready on 1 June 2020, at 5:01 p.m, the seller, all things being equal, has the right to, for example, declare the contract at an end, terminate the contract, and take action. So a very important case is Legione and Hartley. That's Legione against Hartley. 1983, 152, CLR 406. The argument was whether the seller had lulled the buyers into thinking that time would no longer be of the essence. And the statements were made by a conveyancing clerk, almost in an off-the-cuff manner in that case. So be really careful. I'll give you one example, and this is Tanwar, Tanwar, Enterprises, Pty Ltd, against Cauchy, Cauchi. This is 2003 217 315, CLR 315. So what happened? The buyer was Tanwar. Tanwar enters into a contract to buy 3 properties from the seller, which is Cauchy. Problems on the settlement day. Singapore authorities held up money in transit. Time was of the essence. The buyer didn't attend the settlement. The seller terminated the contract, but the buyer's funds became available the next day. The buyer said, I'm ready, willing and able to effect settlement right now. I've got the money. The seller said, no, I've already terminated. Went to the High Court. And the High Court said it was not unconscionable for the seller to terminate the contract when they did. So the whole case was, Tanwar said, yes, time is of the essence as per contract, but it wasn't our fault. The thing, money was held up beyond our control. It's unconscionable of the seller. The High Court said, no, it's not unconscionable. It's contract. So there's a whole range of reasons why they did that, but that's the basic principle. It's just a good example. Now, I mentioned other equitable remedies, injunctions. These can be mandatory or prohibitory. Mandatory meaning a court order to compel another party to do something. It's not quite specific performance, but more commonly, it's to stop a party from doing something. An injunction to stop the other party from selling the property. They can be interlocutory, they can be permanent. And the whole idea is to maintain the situation until there's a proper argument. So there has to be a serious question to try. The party seeking the injunction on an interim or temporary basis needs to establish that they've got an arguable or even prima facie case, and that there is a serious question. And finally, that the balance of convenience, which is paramount, is in favour of the party that seeks the injunction. Usually, that party will then need to give some sort of undertaking as to costs or damages sustained by the other party if they're eventually unsuccessful. Are you doing well? I'm just going to check. I know there's some questions. No. There's a question.
John,
yes.
Can
yes.
you hear me?
Yes.
Yeah, I'd like to ask a question. And it goes back to a distinction that you drew at the beginning of the lecture between legal and equitable interests. And I'm trying to get my head around how the concept of indefeasibility fits between these two. So if I am the registered proprietor of a property in fee simple, I have a legal interest in the property. But if I lease that property to a third party, they have an equitable interest. So no, sort of. Okay. Well, this is where my question is: if the lease fails in some way, and the leasee takes action for a remedy, the title is indefeasible. They can't take action against the title. They can only take action against me. Is that correct?
That's a really good question. And I'll answer it this way. Bear in mind, in week 1, we talked about interest in properties being a bundle of rights and interests, and that a number of people can have interests in the same property. Now, what I should have said and made clear, and I haven't, is that a number of people can have a legal interest in property. The legal entitlement, the legal interest, is not confined to one party only. In other words, whilst the best example, the most common example of having a legal interest in property is to be the registered proprietor in fee simple, as you say, the party that has the benefit of a registered commercial lease over the property also has a legal interest. It's just that their legal interest is different to the legal interest of the registered proprietor. So one has a legal interest as registered proprietor in fee simple. The other has a legal interest in the lease of the property. I hope that makes sense.
Yeah, I should have been clearer. In my thinking, I follow exactly what you've said. I was thinking, though, that it's an unregistered lease in the sense, well, let's say that it's less than 3 years, so it's an unregistered lease. Does the leasee have an equitable interest in the property, or is it still legal?
No, that's a very good question too. And you might get different answers from different people on this. In my view, the interest of the lessee in those circumstances is still a legal interest, even though it's not registered. So that's a kind of an exception to what I've been saying. And the reason I say that is this. We know that under Section 184 of the Land Title Act, there is the paramount interest as a result of indefeasibility. So the whole idea of indefeasibility is that you've got something which is, it's right up there. But Section 185 says, but there are a whole range of exceptions to that. Adverse possession is one of them. And as you've identified, Ivan, having a short-term lease is another exception. Because it's an exception, in my view, and this is arguable, you don't have to have it registered for it to be legal. So when I've talked about having a registered interest as being a legal interest, that's pretty much the rule, but it's subject to these little exceptions and quirks. So I think an example of an equitable lease would be if you, a bit like Waltons and Marr, if you went into occupation and there was an exchange of letters, and we will sign the lease, but it doesn't happen, then I think you've got an equitable lease as opposed to a signed document, which creates the legal lease, even though it's not registered. But if it was a lease that was for 5 years and the law says a lease beyond 3 years must be registered, then you don't have a legal lease, even though it looks the same as the lease for 2 years, because of the additional statutory requirements to make it legal. Oh, I hope that makes sense. Thank you. Good questions. Any other? Oh, no, there was a question about the case I'd mentioned earlier. Baumgardner was the case. Baumgartner. Any other questions? All right. So we're almost out of time. So that's, I guess, the issue of termination versus rescission. And bear in mind the equitable orders that are available at court. Remember, of course, the remedies under the Australian consumer law, which are always very important. And the Australian consumer law incorporates a number of what would be legal and equitable remedies because it talks about, for example, injunctions. Another thing that you might come across from time to time is this distinction between liquidated and unliquidated damages. So liquidated damages are essentially for a set sum, a fixed sum, or a sum that's ascertainable by calculation or by reference to a scale, a fixed scale. Unliquidated is where the sum cannot be ascertained by use of a formula, and a court or a tribunal has to receive the evidence and then make a determination. We think that injury is worth $25,000. That's an unliquidated damages claim. The tenant owes me $25,000 in unpaid rent by reference to the formula in the lease. That's a liquidated claim. So claims for damages can be liquidated or they can be unliquidated. They can be common law or they can be under the Australian consumer law or other statutes. And I promised that I would show you something useful. I know it's coming late. Next week, we'll do our review. This week or early next week, I'll give you some exam hints, really clear exam hints. So sorry that hasn't arrived yet. I'm supposed to do that by week 10. So, but you will get good hints later this week or first up in week 12 next week. And next week, I'll just wrap up a little bit about what we're dealing with tonight, and we will talk about exam preparation. If you haven't seen the Department of Natural Resources, Mines and Energy website, I'd urge you to look at it. I'm going to attempt to share the screen here, and you should see that website. For example, titles and valuations. Please let me know if you can't see that screen. Titles and valuations in the context of what we're talking about is important. And if you look at property titles, you'll find a great resource. You'll see the title registry forms and this manual here, Land Title Practice Manual, is excellent. It's highly practical. It provides a great explanation of some of the basic legal and equitable principles, and it has completed forms. So you can look at that and get a real feel for how these things work in practice. So I'd urge you to look at that, and please look at the website generally. And that will just about do us for tonight. So those of you that are off to evidence, enjoy evidence this evening. Any questions before I wrap up for this evening? All good? Thank you for your patience. We'll get those assessment results out to you in the near future. All the best, and we'll see you next week. Bye then.
Thank you.